hopefully you guys have picked up a lot of great information. And now when you put these things into practice, you know you're going to have to give yourself multiple exposures. And when you put these things into practice, you're going to be amazed how your collection starts to change. Okay? If you need to, of course, you know you can come to my site. You can get the Communication Success Program, the Managing Your Emotions, and of course the Goal Achieving programs to be able to add these skills, whatever level that you're at. If you can develop them without, that's fine. If you can't, we've got those tools that'll take care of you too. Now we're going to talk about legal issues and the things in legal that we do. So if you look over here on 22, it says taking legal and legal issues. Okay, so legal processes, legal is great deal has to do with what the state requires. Basically what you have to do is you have to send somebody a legal notice. Now notices, as we talked about earlier with letters, there's a certain sequence you got to go, and it shows you in your book. You know, you got to give your notice, your second notice, your final notice, and then your legal notice if you're going to sue them. Most states, in fact, as far as I know, all of them require that legal notice. Also certified so the person signs for it. Or you've got to use a process server to have them find it and say, here you go, you've been served. Now, then it depends on the state you're in. And once you get a judgment, because what happens is when you sue them, the court date comes up, and once you win the case, if you got a contractor, most time they just don't show up, the debtor doesn't. But then you get a judgment. In some states you can garnish, in some states you can pick up the property. It depends on what the situation is as far as what you can do. So it's very geared toward the state. Sometimes, folks, it's even geared toward the county. You know, in this county you got to do this. Georgia, South Carolina, where my region was, Georgia differs. They lean toward garnishments. You can get personal property in Georgia, but it's much more geared toward getting garnishments, where South Carolina was more getting personal property. They didn't do garnishment. So for legal, it really depends on the state you're in. But once you get a judgment, that gives you a lot of flexibility as far as what you can do. Some it's put a lien. Sometimes you can garnish their 401ks or savings. So it gives you a lot of options, okay? Of course, now in my business, you really never want to sue a customer. Guys, I probably sued 10 people in 10 years. When I sue you, I lose you as a customer. I did not sue you unless I knew there was no other way to get this money. And I'm not going to give you the money because I'm paid by the company to recover the money. So unless it was a lost cause, and if you refuse to pay and we'd gone out of our way to collect effectively and you still wouldn't pay, that's where legal comes in, okay? But you do got to use the state processes, as you see the laws right there, okay? Post-dated checks, the Fair Debt Collection Practice Act, which is federal law, says that we can take a post-dated check from a person as long as we give them a letter on our letterhead, on the company's letterhead, that says we will cash the check this day, no more than 5 days out. So if we don't give them a letterhead, meaning if you get a post-dated check through the mail, you got to send it back. Also, with post-dated checks now, you got to remember states can add to, just like in the state laws, but they can't take away. So where federal says you can hold a check 5 days if you give them a letter with your letterhead, a lot of the states say no post-dated checks. Georgia, for one, it's against the law to write or receive a post-dated check. They don't do post-dated checks. So you've got to look at your state law to determine what is the right thing with post-dated checks. But guys, look at this. A post-dated check, you can only hold it for up to 5 days. It doesn't mean it's actually good anyway. If somebody were to break in your office and steal it, you'd be responsible. There's really no good reason to keep a post-dated check. But the federal law is that 5 days with the letter. Wall of shame, we talked about that at the beginning of the course, and it's still not legal. You cannot list or make a list of deadbeat customers. You can't do it. You can't have the NSF checks or you know, any way identifying that. You can have a list of customers you won't deal with, or you have certain restrictions based on collections delinquency, but that has to be an informational operations use, not a wall of shame, so to speak. Partial payments, guys, you have to be careful with this, and it is a legal issue because in my business, let's say you owed me $300 a month, and you sent me a $100 payment, I cashed it, and down the road, I sued you for the rest of the money. And the judge is going to look back at the record and he's going to say, Tone, I see back here you took a $100 payment. Why won't you take $100 payments in the future? Why haven't you been taking else? And I say, well, Your Honor, I don't take partial payments. Well, you did. And so what he or she's probably going to do is just rewrite my contract, look at the customer and say, from now on you pay me $100 a month. Which means I'm going to carry this thing in arrears past due. It's going to hurt my operation. So in my line of business, not in all, but in my line of business, we couldn't take partial payments. It would go directly against our business. But guys, if I'm business to business and Walmart says, Tone, I know you owe you $150,000 on the account, but I'm going to give you a check today for $75,000. Do you think I'm not going to take that check? So it depends on the business, but yes, I would absolutely take that check. Guys, if you look over here on page number 23, we start talking about bankruptcy. Now, this is one of the things that a lot of us run into with customers. Bankruptcy. What we normally find is we have chapter 7s and chapter 13, so a lot of us run into that. Of course, that's with your consumers, individuals. And then you have chapter 11 for commercial. All right, so 7 and 13. In chapter 13, you get a bankruptcy notice, and in that comes the notice, the chapter 13 notice. That notice is going to have a date on it, that is court date for that customer. It's also going to have a form with it called a proof of claim. Now, what you want to do is you want to fill out the proof of claim, which wants to know the balance of the account, break down the principal and interest of the account, right? It wants to know, and then whether you're secured or unsecured account. Now, like we used to take collateral, but we didn't put a lien on anything. We had a collateral sheet and an agreement that we could take this if you didn't pay, but we didn't put a lien. With that said, with no lien, we weren't secured, so I was an unsecured debtor. So if you don't actually have a lien on the house or the car, then you're an unsecured debtor. Now what you do is you fill out your proof of claim with that information, and then there's going to be a court date, and you go to that court date, because what a lot of times what they'll do is they'll just simply say, is this creditor here, is that creditor here? They look at the contract, and they put you for a chapter 13 guys on the list, and you get your money back. It might be 10 cents a time, but you get your money back over time, most of it. Now, if you don't go to court, my experience is a lot of times the matters just to say you must not want the money, and they put it away. So for 13, you want to fill out that proof of claim, and you want to go to that court date. You just take the contract and just show it. For a 7, if that goes through, if it all goes all the way through and it's discharged, then you can't, if you're secured, you might end up with your property or they allow it to reaffirm, but other than that, if you're unsecured, you can forget it. You're not getting anything, okay? 11, when you come to companies and you come to commercial operations, a chapter 11, guys, it depends on a lot of different variables there. There's restructuring, there's selling off assets. You got certain, sometimes names and trademarks you can sell. Let's say it's a small town with one sewing factory and it's going bankrupt. The judge will probably try to help that factory stay in business because it's going to hurt the town itself. So there's a lot of variables there with a commercial chapter 11. The one thing I want to tell you there is be involved. Be involved. Make sure you stay involved, and you might come out with something. If you're secured, you're going to be okay with some of it, but if you're unsecured, depending, you may end up with nothing. Okay? But bankruptcy, the main thing is make sure you're involved. Also with the bankruptcy, you have to make sure the customer actually finishes the process and the bankruptcy is discharged or dismissed, one or the other. Discharge means that the bankruptcy went through, it was performed, it was done. Dismissed means it was dismissed, dropped, let go. So dismissed means that it's been done. So what you want to do is you want to make sure that no more than 30 to 45 days, if you haven't actually got a dismissal letter or a discharge letter, call the attorney and make sure that they did go bankrupt. A lot of times what happens is they'll start it, you'll get a notice, they'll stop, and you think they're going bankrupt, you'll just stop collecting. So you got to follow up. Guys, that is collections law. Now, add the skills you need, get the skills, perfect them. Remember, you want to have to practice, practice, practice. Make collections easy for you. Watch these lessons multiple times, but make it easy for you. Of course, come back to the site if you need any of the other skills as far as the goals or the communication success program. It was a pleasure, and if we can help you, let us know. Thanks for coming and using our products.